Would the Enoch Burke situation have developed in a different way? What would you do as an employer if you were confronted with an employee who had a particular issue or difficulty in the workplace? What should you do as an employee if you have a difficulty or an issue in the workplace with perhaps an instruction that you've been given? In this video, I'm going to discuss the alternative route and an alternative scenario as to how the Enoch Burke dispute with Wilson's Hospital School could have panned out. Once Mr. Burke received the instruction or direction or request from the principal to address a particular pupil with the they pronoun, then Mr. Burke, by his own admission, had a difficulty. He had a significant difficulty because he believed that he couldn't do that, he couldn't follow this direction, this request, on the grounds of his religion and his religious beliefs and so on. So he was faced with a difficulty. Most people will be aware of how that he dealt with that difficulty and the events that transpired after that. But in this video, I want to look at the employment law aspects here and see or put forward, advance an alternative scenario whereby the matter might have been dealt with. This might be useful for employees and it might be useful for employers, because employees have all sorts of issues in the workplace and employers face all sorts of issues in the workplace. Obviously, it's not going to be sensible or cost effective or pragmatic for either employee or employer to end up, for example, in the High Court looking for an injunction, or to be looking for an application to have an employee incarcerated, jailed basically. So what I'm going to look at here is what could have happened. What was the alternative? The first thing that the employee could have done was to look at the staff handbook and use the available procedures in the workplace. The workplace we're talking about here is a school, and the Department of Education and various schools and the trade unions, the TUI, the ASTI, the INTO, all of the trade unions down through the years have fed into and participated in the procedures, in agreeing procedures for all sorts of difficulties and issues that might arise in the workplace. In this particular case, in Mr. Burke's case with Wilson's Hospital School, when Mr. Burke was requested or instructed, depending on which side of the fence you might be, to address a pupil with a particular pronoun, then Mr. Burke had the opportunity to avail of, for example, the grievance procedure. So the grievance procedure in the workplace, especially in schools, but in most workplaces, and the grievance procedures and other procedures are well established in the education sector. I'm looking at the grievance procedure there now on the screen, and it's one that's agreed between the joint managerial body in relation to voluntary secondary schools and boards of management, and agreed with the Association of Secondary Teachers of Ireland, ASTI, the trade union. This grievance procedure, however, is practically identical to the procedures in all of the other schools in the education sector, including secondary and primary. So in the first instance, stage one of this particular procedure looks at the teacher will discuss the grievance with the principal teacher, etc., with a view to resolving it. That's stage one. Stage two then is the teacher and or the ASTI or school representative will give notice to the principal and manager or chairperson of the board that the grievance procedure is being invoked. In other words, it hasn't been resolved at stage one. We've moved on now to stage two with a notification to the principal and the manager or chairperson of the board of management. Stage three then involves the teacher and or his representative giving notice in writing to the chairperson of the board of management that stage three of the grievance procedure is being invoked, and That's a written submission would be made then by the teacher and or the trade union representative or other representative to the chairperson for consideration formally by the Board of Management. That's stage 3. And after that then there is a decision in writing of the board in relation to the grievance, and at stage 4 then, if the teacher is not happy with the outcome, then the teacher may wish to appeal the decision in writing. And then the appeal will be dealt with by a tribunal which shall consist of an agreed independent chairperson, 2 persons not associated with the school, etc. And then obviously after that stage 4, if the teacher is still not happy, well then they could go to the Workplace Relations Commission. Before we go to the Workplace Relations Commission, that is the grievance procedure that is in the education sector in Ireland. It involves 4 stages. It involves a mechanism by which teachers can raise issues, raise difficulties that they have, especially in relation to requests or directions from perhaps the principal or whoever, and that's the procedure. So 4 stages to it, involving an appeal to an independent tribunal if the teacher is not happy with the outcome in the earlier stages. That is the grievance procedure. In addition to the grievance procedure, most workplaces will have a dignity at work procedure. Dignity at work procedures involve the ventilation or dealing with issues that teachers might have or employees might have in relation to, for example, harassment, sexual harassment, discrimination, etc. If in this particular case, when talking about Mr. Burke's case there, what might have happened, if his decision or if his view was that his religious principles, his religious views were not being sufficiently taken into account, he could have, rather than using the grievance procedure, used the dignity at work procedure. Basically, it would be a similar procedure to the grievance procedure, except he would be arguing that his dignity at work, his dignity as a person and as an employee, was not being afforded to him in the workplace by reason of the school's failure to take into account his religious difficulties, his religious or his objections on religious grounds to the request to use the they pronoun. So that's the second procedure or policy that Mr. Burke could have availed of, the dignity at work procedure in the workplace. If he used either the grievance procedure or the dignity at work procedure and was unhappy with the outcome of those procedures, then he could submit a complaint to the Workplace Relations Commission. The Workplace Relations Commission would then, pursuant to the Industrial Relations Act 1969, Section 13, Subsection 1, appoint an adjudicator to investigate his trade dispute. So his complaint would essentially be a trade dispute as understood by the Industrial Relations Act 1969, and an investigator or investigation would be carried out by the adjudicator for the WRC if the employer did not object. By that I mean, once the WRC received the complaint from Mr. Burke, the trade dispute complaint, well then the WRC will write to the employer and say, we have received a complaint. We're being asked to investigate under the Industrial Relations Act 1969 this particular complaint about this man's religious beliefs not being fully respected and not being afforded dignity in the school, in his workplace, and we propose carrying out an investigation and making a recommendation because that's what he has requested. They will write a letter to the school, however, and say, do you object? And if you object, just tick the box. That means that the school could object to the investigation. However, that is not the end of the matter, because Mr. Burke could then submit his same complaint, the same trade dispute, to the Labour Court. And the school could not prevent the Labour Court from investigating it and making a recommendation. Now, the recommendation would be a recommendation only. It wouldn't be a binding, enforceable decision or determination. It would be a recommendation. The school could choose to participate in the hearing or not, but if Mr. Burke got a successful recommendation, well then he could seek to enforce that at the school with the support of colleagues and with the support of, for example, a trade union. Whilst the recommendation under the Industrial Relations Act 1969 is legally unenforceable, it does have some moral and persuasive effect, especially in circumstances where, for example, a trade union would be involved. Once a trade union gets involved then, and if they are going to assist the employee, Mr. Burke in this case, then you could have a picket or some sort of, not so much a picket, but certainly a protest outside the school, and it could be along the lines of, we have, or Mr. Burke has received this recommendation from the Labour Court. It's in his favour. The Labour Court recommends X, Y or Z, and it is not good enough that the school simply ignores it. And if Mr. Burke then had the support of colleagues and or the trade union, well, that would certainly have a good degree, I would have thought, of moral or persuasive authority, because it would be on foot of a Labour Court recommendation. It's not just this stage, it's not just Mr. Burke's opinion or idea or his argument. It would be a recommendation from the Labour Court. So that, even though it is legally unenforceable and non-binding, and the school could ignore it, the school would definitely be in a very awkward position if there was a legitimate trade dispute, a legitimate protest outside involving a number of teachers and involving a trade union. If the teacher then found that it was a futile exercise and that perhaps other teachers were not going to get involved and support him, or perhaps the trade union, he may not be a member of the trade union, I don't believe he is a member of a trade union, but if he wasn't happy with the outcome of that, well then, and didn't wish to protest at the school pursuant to or emboldened by the recommendation from the Labour Court, then the employee could decide, well, this school is not for me. I am going to, on a point of principle, not use the they pronoun. I'm going to resign, and I am going to resign on the grounds that my religious beliefs are not being sufficiently protected, and on a point of principle I'm going to resign and get a job somewhere else. Mr. Burke then could have resigned and simply gone to another school, got another job, and that's an alternative scenario, that's an alternative way of dealing with this matter. And if Mr. Burke was unsuccessful at the end of it all, then he simply could have resigned on a point of principle and got a job in a different school. There are plenty of jobs in schools, and teachers are in high demand, and good teachers are sought after, very well sought after. So I'm putting forward this alternative scenario, this alternative way, this alternative route to this particular dispute. But what I'm suggesting is that this could have been, or this could be a route that any employee or any employer will have to consider if a similar situation arises in their workplace. In other words, a teacher or an employee, not just a teacher, may have a difficulty or an issue with something else entirely. It may not be related to any issue of sexuality. It may not be related to any issue of religion. It may be something else entirely. But if an employee comes to a solicitor and looks for advice in such circumstances, well, the advice would always be to firstly avail of the internal procedures, and secondly avail then of the Workplace Relations Commission and see where you are at the end of that. Hope you find this useful and perhaps thought-provoking, and perhaps it will be of some assistance, I hope it is, to other employees and indeed employers if they are faced with a difficult situation and a situation where an employee in the workplace has some issue or concern. Why would you choose this route, this particular alternative route that I'm setting out, rather than the one that Mr. Burke chose? Well, you could consider one, costs, legal costs. the way I'm suggesting wouldn't really involve any legal costs apart from perhaps a consultation with a solicitor if that was necessary. Another advantage of going this route would be the career. The employee's career in the hypothesis that I'm advancing in that route would be unaffected, because essentially an employee would be resigning from his job or her job in a particular location and getting a new job. That could happen for all sorts of reasons. It could happen on the grounds of principle, it could happen for lifestyle reasons, it could happen for all sorts of reasons. But from the point of view of protecting and advancing one's career, the route that I'm suggesting, what I've set out in this video, I would suggest would be better from a career perspective. The downside of what I'm putting forward is it wouldn't involve much publicity. There'd be no publicity. And perhaps that's something that might motivate an employee. I'm not sure. I know a lot of employees wouldn't like the publicity and wouldn't like to damage their career prospects and wouldn't like to incur legal costs and fines and so on and so forth. So that's it. You paid your money, you take your choice. All I'm doing in this video is advancing an alternative route, and for any other employee or indeed employer who might be faced with a difficulty down the line in terms of an employee having an issue in the workplace, I would suggest the procedures in the workplace ought to be ventilated first. If you like the video, I'd appreciate if you gave it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. You may be listening to this as well on my podcast, the Irish Law and Small Business Podcast, which you can access on Spotify or iTunes or YouTube. If you are listening on the podcast, I'd appreciate if you left a review. Thanks a lot.